Bassett, how are you?
Good, how are you?
Good, thank you.
The record, Cynthia Bassett, on behalf of the plaintiff, Christa Means. My client is on Zoom, Your Honor.
Hi, Miss Means, how are you?
I'm well, thank you.
Can you state your name for me?
Christa Means.
Okay, and Mr. Means, how are you?
I'm doing well.
All right, can the parties, Mr. Means, can you state your name?
Randell Clifford Means.
Okay, can the two of you raise your right hands to be sworn in?
Do you swear or affirm that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
Yes.
I do. Yes.
Okay, go ahead, Miss Bassett.
Thank you. Miss Means, do you recall signing a complaint for divorce in my office?
Yes.
Was everything true when you signed it?
Yes.
Is it still true today?
Yes.
Had you lived in the state of Michigan for 6 months before you filed?
Yes.
And Washtenaw County 10 days?
Yes.
And you and your husband have 2 minor children, correct?
Yes.
Are you pregnant now?
No.
You stated in your complaint that there has been a breakdown of your marriage to the extent that the objects of matrimony have been destroyed, and there remains no reasonable likelihood that your marriage can be preserved. Is that still true?
Yes.
Is there any chance of reconciliation?
No.
We're presenting the court with a proposed default judgment of divorce today. Have you had the opportunity to read that judgment?
Yes.
No, Ms. Means, you read
Yes.
the judgment?
Yes.
And did you understand all the terms of that judgment?
Yes.
Do you believe all the property and debt division provisions are fair and equitable?
Yes.
You also provided in the judgment terms of custody, parenting time, and child support for your children. Is that correct?
Yes.
And you understand all those terms?
Yes.
And you believe they're in your children's best interest?
Yes.
And you understand that neither of you has been awarded spousal support?
Yes.
You're asking the court to restore your prior name. Is that correct?
Yes.
Name is that?
Christa Mann.
Middle name, please.
Ann. Christa Ann Mann.
Okay, thank you. And you're satisfied with all the terms as presented today?
Yes.
And you're asking the court to assign your judgment today along with the uniform child support order, correct?
Correct.
No other questions, Your Honor.
Thank you. And this complaint was filed. Mr. Means failed to file a complaint answer the complaint, correct, Ms. Means?
Correct.
And the clerk entered a default judgment at your request on October 3rd of 2025, correct?
Correct.
Correct.
Okay. And that default judgment the default entry was served on Mr. Means on December 19th of 2025.
Correct.
And notice of today's hearing was served on March 10th of 2025.
Correct.
And the proposed default judgment was served on March 25th of 2026. I'm sorry, March 10th of 2026. That was the date the notice of hearing was served. And March 25th of 2026 was the date the default judgment was served, correct?
Correct.
Okay. I do find based on the testimony that there's been a breakdown in the marriage relationship to the extent that the objects of matrimony can no longer be preserved and there remains no likelihood of reconciliation.
I'm sorry. Your Honor?
Yes.
Yes, I'm contesting it.
You are here to contest the judgment?
That is correct. I'm not agreeing to I'm not agreeing to the consolidated debt, nor am I agreeing to the custody of the children. For one, the consolidated debt, I sent $18,000 over the last 2 years of our separation for daycare as well as bills. For two, when it comes to the children, over the last 6 months, I've had 3 separate police welfare checks on my children from Pittsfield Township Sheriff Department. I had those checked in where she left my children with her my stepson. That the reason they moved to Ann Arbor, he was going to commit suicide in Canton, Michigan with his grandmother. So she changed school districts for him. So she left my children with him on 3 separate occasions over the last 6 months to go on dates with other men, infidelity. And I have the documents as well for the $18,000 I sent over the last 2 years. Also being served in December for divorce, while I've been unemployed since May of 2025. Her brother, Joseph Richard Mann, that lives in Indiana. My son, she took my son down there, my 5-year-old son, for a visit, and he had a serious accident where he had to go to the hospital. I contacted her brother through Facebook Messenger, trying to find out what's going on. No one gave me answers. Her brother had a PPO against me, which got me fired in May of 2025 for my 60K job as a material planning analyst. And with that happening, I didn't find out that they had a warrant for my arrest until I got hired to a new job in November of 2025. So whatever she served me in December for the divorce, I was in St. Louis, Missouri for a new job with Life Couriers in Romulus, Michigan for nuclear medicine distribution. And they had to fly me right back to Michigan when they told me it was a warrant for my arrest. I got fired immediately from that new job from her brother in Crossroadsville, Indiana, Joseph Richard Mann. I just had a case with that situation on April 2nd of this month. So this case right now is April 9th of 2026. I just had a case in Crawfordsville, Indiana, April 2nd, 2026. They're putting it as a misdemeanor, 1-year probation. They're working that out. So I go back to court to get my 1-year probation with them in the state of Michigan. I live in Detroit. So that's one situation, but also I also need time to get a legal aid attorney since I've been unemployed, even though I'm going through interviews, to contest the $29,000 debt that is not our debt together. I am not on the contracts of the lease we had in Canton, nor am I on the daycare thing, but also I still sent money, and I have the records of the $18,000 I sent over the last 2 years.
Okay. Mr. Means, I understand your objection and I understand why you're making it. There's a very specific procedure that I have to follow under the Michigan court rules relative to service and entry of default. You have mechanisms that you could have filed that you didn't.
No, I did file. I filed. I sent to your email. I filed my disagreement paper, whatever the thing is. This thing I filed. I sent it to the email to the court. Contested it. I sent that probably as soon as I was served with this default a couple weeks ago. So I sent that through the email to the court.
I understand that you've been emailing a lot of emails to the court, but nothing that you've sent was a proper filing under the court rules. So the thing that you could do now, once this judgment is entered, is either file a motion for relief from judgment or file a motion to modify the judgment. But I would suggest you get an attorney to do that because the things that you've been sending have not been proper filings.
No,
I know
the first initial paperwork I sent was through the actual proper form for the court to contest this hearing or whatever the judgment. That's what I initially sent the first time before I sent any other emails pertaining to court. That was the first initial thing I sent. But like you said, if I have to get a court-appointed attorney, legal aid attorney to contest whatever modification I need to do, I guess I'll have to go that route.
Okay. 1 second here. So I see that there was a complaint, a summons, a UCCJ affidavit filed, and then a default request, notice of intent to dismiss for lack of progress, Zoom notice of motion hearing scheduled, and then another one scheduled. I'm not seeing anything that you filed.
One second,
officially
ma'am.
filed. So you,
One second, ma'am.
need-
I sent it. I
I
sent.
want you to be clear. No, Mr. Means.
Yes,
I'm
I hear
looking
you.
at the register.
I hear you.
Emails that you send to my chambers is not a filing with the court.
No,
Although I'm the court,
ma'am.
file with the
Ma'am, I'm trying to say that I sent the actual file, the initial file. I'm looking up on my email chain. The initial one I sent, answer to complete. Here it goes. Divorce hearing. This was sent on
I don't.
March 30th.
Who did you email it to?
I emailed it to. I said, "Good morning, Judge Hamoud, Millard."
Stop. Mr. Means, read to me who is in the email to line.
March 30th, 2026, Millard at washtenaw.org, Matthew at washtenaw.org, Hayward at washtenaw.org. There was a document attached, answer to
All right, can
complaint.
you stop right there? I'm trying to teach you something, Mr. Means. Mr. Matthews is the court administrator. He's not the clerk. Ms. Hayward is the judicial coordinator for the court. She's not the court clerk. Mr. Miller is the judicial attorney. He is not the court clerk. If you're filing electronically, you have to create an account with MyFile. Once you have an account with MyFile, you can file the pleadings. Otherwise, you need to come in person and file downstairs with the clerk. So your pleading was not accepted. It is not appropriate to file things by email to court staff.
Okay, so like I said, everything that was done illegally initially in general. So like I said, whatever I have to do to whatever relief I got to remotion or whatever I got to do with an attorney, please let me know what I have to do and I'll take care of that through time. It's a civil matter.
All right, so
Thank you.
I am entering the default judgment of divorce that I told you what you would need to file it if
Could you repeat
an
it? Could you
attorney
please
suggested
repeat it,
that-
Judge? Could you please repeat it?
I said if you retain an attorney and they think it's appropriate for you to file a motion for relief from judgment or a motion to set aside the judgment, that's what your next step is. But I'm proceeding with the entry of this default judgment. I am making a modification, Ms. Bassett. And I think I said I do find based on the testimony that there's been a breakdown in the marriage relationship to the extent that the absence of matrimony can no longer be preserved. There remains no reasonable likelihood of reconciliation. I find the provisions regarding the minor children to be in their best interest based on the testimony provided.
Wait, what testimony did I give? And what also, I'm not aware of a lot of this stuff.
This is a default entry. So the only testimony I need to hear is from Miss Means anyway. She's the plaintiff in this case.
I've had 3 separate police reports and I had a felony charge in Kenton, Michigan because of her family as well as her. I don't understand what's going on here. Like, this is all illegal. This is all illegal. This is all illegal.
Mr. Means, you have continued to engage in conduct that's inappropriate, whether
I could care less. This is all illegal. It's the facts. It's illegal.
200 emails to my staff.
Hey, it's illegal. It's illegal. It's illegal.
Okay. Can you please mute Mr. Means? Because I'm issuing a ruling now.